Good afternoon, everybody, and happy Constitution Day to you all. And it's my pleasure to welcome you all to today's Constitution Day event. It's also a Politics Forum event, our first Politics Forum event of the semester. Looking ahead, we'll be sending out emails in the weeks to come to advertise upcoming events, all of which will be in October and November. For those of you who are new to the College of New Jersey or new to Politics Forum programming, the Politics Forum is sponsored by the Department of Political Science, and it's an opportunity for scholars both at the College of New Jersey and at other schools to give presentations to the TCNJ community about their areas of research in the study of politics, broadly understood. And from semester to semester, we usually have somewhere between 4 and 6 speakers, both again from on campus and from off. Today's speaker, however, is a faculty member here at the College of New Jersey. Professor Dumas is an associate professor of political science. She teaches courses in constitutional law, civil rights and liberties, law and society, and judicial politics. Her research focuses primarily on the role of institutions and contextual factors in shaping litigation outcomes in United States trial and appellate courts. Dr. Dumas is currently working on projects exploring the role of lawyers in settlement and litigation processes, and research investigating the influence of judicial selection methods on the behavior of trial court judges. Her talk today is entitled 2 Steps Forward, 1 Step Back, the Incremental Advancement of and Persistent Threats to Voting Rights in the United States. And with that, I will turn things over to Dr. Dumas with the understanding that after her talk, there will be plenty of time for discussion, and attendees can make use either of the chat function or they can unmute themselves for the sake of asking questions. But for the moment, I will turn things over to Professor Dumas.
All right, so welcome to this year's Constitution Day talk, COVID edition. So, funny story. When I was getting ready for this talk, I decided I would get dressed the way that I normally would to give a talk. And I put my outfit on and I realized I had a nice, perfect little line of dust across both sleeves of my jacket and then right across the top of my pants where they lay across the hanger. So apparently I and my outfit are both a little bit dusty. So hopefully this goes smoothly. Wish me luck. So the purpose of this talk is to talk about voting rights, which have been a central topic of discussion over the course of the summer, and particularly because we are in a presidential election year. So the talk is really about trying to both understand our voting rights in the United States, but also to put a context on the many things that are happening in current events right now. So the central thesis of this talk is that while we face unique threats to the right to vote, voting rights issues have been central to the struggles in American democracy since the founding. And with each expansion of voting rights have also come new restrictions. So the talk will proceed in 4 sections. So the first part of this is to discuss constitutional authority over elections and sources of voting rights. Then I want to talk about the Supreme Court's interpretation of voting rights through the lens of Supreme Court case law. Then we can discuss some contemporary issues and some potential pathways for change, and then follow that up with a chance to answer your questions. So my image there of 2020 sums up a lot about how we're all feeling about this year. And then we can add to that all of the things going on with elections right now. And so just a handful of things that you may have noticed from the headlines that you were reading as you came into this talk are international interference in our elections, the potential for hacking of our elections, outdated voting machines, securing mail-in ballots, under-resourced post offices, voting in person during a pandemic, changes to registration and voting rules, felony disenfranchisement. And then I decided Florida deserved its own bullet point. You know, maybe I shouldn't pick on Florida, but I kind of get the sense that they've actually earned this one when it comes to sabotaging elections. So Florida gets their own spot on my list. And then perhaps what's always the biggest threat to voting in the United States is apathy and disillusionment. And so I would like to come back to these topics later on, but first, what we need to learn is a little bit about voting rights and elections in the United States. So the first part of this talk is going to talk about the constitutional authority over elections and sources of voting rights. And so a good place to start this is the election of 2000. And so there's Florida. For those of you who remember the year 2000, you probably remember that waking up the day after the election and not knowing who the president of the United States was, and not knowing who the president of the United States was for quite some time after that election. So to refresh your memory, or for those of you who weren't around to remember this, what happened was that there were a large number of votes in the state of Florida that could not be processed through traditional voting machines. When that happened, the Supreme Court of Florida called for a hand recount of those ballots where the voter's intent could be discerned by individuals looking at those ballots. When the Florida Supreme Court called the recount, candidate Bush sued candidate Gore to stop the recount. And so this case then goes on to the Supreme Court of the United States. And the Supreme Court tells us two things that are really important for our purposes today. And so the first one is that state legislatures control the times, places, and manners of elections. So who determines what elections look like in a state? Your state legislature. So part of the reason why there is so much variation in terms of how you register, how you vote, where you vote, when you vote, is because every state legislature is charged with doing that themselves. The other thing that's important about this case for our purposes today is that the Supreme Court ended the recount on a 5-4 vote, with the 5 Republican appointees voting in favor of Bush and the 4 Democratic appointees voting in favor of Gore. And so the other thing you'll see throughout this talk is that the Supreme Court has been very divided on these issues, much along party and ideological lines. The other thing that the court says in this case is that courts have little to no involvement in elections. So when the Florida Supreme Court ordered the recount, it violated the Constitution because who controls elections? The state legislature. And so when the courts inserted themselves into this role, they were actually violating the Constitution. So 2 take-home points here. 1, state legislatures are the ones who control elections, and 2, courts have little to no involvement in the election process. All right, so now we know who controls elections. Let's talk about where the rights to vote actually comes from. So I see some of you are raising hands, and that's great. I am going to wait until the end to answer your questions. So just so you know, trying to keep up with the chat and talking to you all, I find to be way too distracting, but I will get to your questions at the end. All right, so where does the right to vote come from? And this is a Constitution Day talk, so you're perhaps not surprised to find out that it comes from the Constitution. You might, however, not know that the original document in 1787 actually didn't say anything about a right to vote. The other thing that we know about our Constitution is that while it was surprisingly democratic for its time, there were large segments of our population that couldn't vote. Just a few examples, we know that enslaved Americans were denied the right to vote, Native Americans were not allowed the right to vote, women were not allowed the right to vote, and other groups in other states were denied voting rights. So even at the time where we were expanding the right to vote by creating the Constitution and our constitutional democracy, we were also denying large subsets of the population voting rights. The other thing that happens at this time is that many states were actually scaling back their voting rights. So New Jersey, for example, allowed anyone who owned property to vote during the colonial period and the Revolution. It actually wasn't until 1807 that New Jersey changed its voting laws to only allow white men to vote. And so certainly there were economic and societal reasons why women and people of color weren't able to own property, but you actually had those groups in New Jersey lose their right to vote over time. So once again, we see an expansion of voting rights, but at the same time, we also see a contraction. All right, so no mention of this in the original Constitution, so where does the right to vote come from? So the 14th Amendment doesn't expressly give people the right to vote. However, it does determine that all persons born in the United States are citizens, and it grants citizens the privileges and immunities of the laws. It grants them due process of the laws and equal protection. And so while the 14th Amendment doesn't give people a specific right to vote, it is actually very important for voting rights because it allows people to bring cases abridging their rights to the courts. It's not until the 15th Amendment in 1870 when the Constitution finally says that citizens have a right to vote. And that right to vote cannot be abridged based on race, color, or previous condition of servitude. So one might think, now that we have a 14th Amendment making everyone a citizen and giving citizens rights, and that we have a 15th Amendment giving everyone the right to vote, that now everybody would just have the right to vote. But that doesn't happen. And instead, significantly less than half of the population has the right to vote after the passage of these two amendments. So to understand why that is, we then have to talk about the way that the Supreme Court has interpreted voting rights. So the first case that I want to talk to you about is Minor versus Happerstad. And so this is a case you probably haven't heard of before because we don't really talk about it very much. But it's also still very contemporary, relevant, and important for voting rights. So once again, citizens have rights to vote. Everyone's a citizen. So why is it that women don't have the right to vote? And so the Supreme Court hears this case 4 years after the enactment of the 15th Amendment, arguing that the 14th Amendment should give women who are citizens the right to vote. The Supreme Court, however, determines that women actually don't get the right to vote under the 14th Amendment. Here's why. So according to the court's majority, neither the 14th Amendment nor the Constitution itself made all citizens voters. How do you know this? Well, women were citizens before the 14th Amendment, and women couldn't vote before the 14th Amendment. Therefore, voting is not necessarily one of the privileges and immunities of citizenship. The court goes on to say that suffrage is not coexistent with citizenship. And so the reason why this case is really important is that we have never had a right in the United States as citizens that is specifically to vote based on your status as a citizen. And so when we start talking about things like felony disenfranchisement and why certain people can be denied the right to vote at certain times, this is why. Because citizenship and voting are not synonymous under the United States Constitution. All right, so what happens after Minor versus Happerstat is that we get the 19th Amendment. And so one of the other reasons why the year 2020 is important for voting rights is that the 19th Amendment recently had its 100th birthday. So the 14th Amendment says the right to vote, the 19th Amendment says that the right to vote cannot be denied on account of sex. So we now have a 14th Amendment making people citizens and giving them rights, a 15th Amendment establishing a right to vote, and a 19th Amendment saying that it cannot be denied based on sex. So once again, we'd think that we've expanded voting rights and everybody should now have a right to vote. But once again, that's also not what happens. So we have to acknowledge that African Americans, men and women, were denied rights to vote in the South, but also in other parts of the United States, even following the 19th Amendment. Something else that you might not be aware of is that Native Americans, while they were native to the United States, did not become citizens until 1924. And since Native Americans weren't citizens, they weren't able to vote until the passage of the Snyder Act in 1924 that made them citizens. Additionally, the Chinese Exclusion Act prevented Chinese immigrants from becoming citizens, which in turn prevented them from voting until 1943. So once again, an expansion of rights, but significant efforts and laws being passed to prevent certain groups from exercising those rights. So the next group to seek rights is through the civil rights movement of the 1960s. So another reason to talk about voting in the year 2020 is that we lost a great civil rights leader in John Lewis, who is famous for advocating for voting rights. And so John Lewis is pictured there on your screen, crossing the Edmund Pettus Bridge, and the violence that happened in their march for voting rights that was broadly televised is seen as being one of the big things that led to the Voting Rights Act of 1965. So the most significant legislation to ever come out of Congress dealing with voting rights is the Voting Rights Act of 1965. And the Voting Rights Act does basically two things. First, it bans literacy tests. These were tests that were given to prospective voters to determine whether or not they could vote, that were largely used simply as ways to discriminate against African American voters. The other thing that the Act did is it develops what becomes called preclearance. So preclearance determined that any jurisdiction in the United States where less than 50% of the non-white population was registered to vote in 1965 had to go before a federal court and able to change their voting laws. So we know from history that what happens after the Voting Rights Act is that we had a massive expansion in the rights to vote for African Americans. The Voting Rights Act, however, gets challenged almost immediately after its passage. So in 1966, the Supreme Court heard the case of South Carolina versus Katzenbach, in which the court ruled on whether or not the Voting Rights Act was constitutional. And so at the time, the state of South Carolina argued that states control elections, and the Voting Rights Act was taking away their constitutional power to control elections. And what the court said in 1966 was that the 15th Amendment gave Congress the power to enact whatever means were necessary to enforce the 15th Amendment. And they also state that the 15th Amendment supersedes states' powers and was intended to do so. So in 1966, the Supreme Court upholds the Voting Rights Act, which creates the ability to have a massive expansion of voting rights. However, the Supreme Court revisits the preclearance provision in 2013. And so in 2013, the Supreme Court hears another case called Shelby County versus Holder. So in Shelby County, the court also addresses the question of whether or not the preclearance provision is constitutional. And so what the court says at that time is the formula they created, the 50% voting standard in 1965, was no longer applicable, and that Congress needed to update that formula. And so the quote you have there comes from the case. While any racial discrimination in voting is too much, Congress must ensure the legislation is the remedy to the problem of current conditions, right? So basically what this case does is it leaves the Voting Act in place, but it removes the formula that determines what areas of the country are included under that provision. And so to really understand the impact of Shelby County on voting, I think we actually have to take a step back and talk about a case the Supreme Court heard in 2008. So in 2008, the Supreme Court makes a ruling in a case called Crawford versus Marion County. So at the time, Indiana was one of the first states to enact a voter ID law. And the Indiana law was very strict in terms of everyone who voted needing to have some form of state-issued photo ID. The law also passed the Indiana state legislature with all of the Republicans voting in favor of it and all of the Democrats voting against. And so Democrats in the state argued that the point of voter ID laws was to suppress the vote for particular populations, minority and low-income groups in particular, and anyone else who was less likely to have a state-issued ID. Also that these tend to be voters who vote Democrat. And so they argued that this was really just a partisan-driven law. There's also no evidence in Indiana at the time that in-person voter fraud was happening at all. So you have a very strict voter ID law that gets passed. It gets passed along entirely partisan lines. And there's no evidence that it's addressing an actual problem. So this case goes to the Supreme Court in 2008. And according to the majority, all of whom are Republican appointees, with 3 Democratic appointees dissenting, this imposes only a minimum burden on voting rights. The majority says that it doesn't matter if there's no evidence that in-person voter fraud is happening because the risk of voter fraud is real. And because the risk is real, the state has a legitimate interest in doing something about that risk. Moreover, the court says that it doesn't matter that this was a purely partisan law because partisan politics are what drive the legislative process. So the 2008 decision allows states to enact very restrictive voter ID laws targeting certain populations. And so the combined effect of Crawford versus Marion County and Shelby County is that a lot of states are now able to enact these restrictive voting ID laws that wouldn't have if Shelby County hadn't happened a few years later. So the graphic that you have in front of you is actually a graphic of the states that have enacted restrictive voting laws since the Shelby County decision. The only states that were under the original pre-clearance prior to 2013 that have not enacted restrictive voting laws are Louisiana and Alaska. And so most of these other states that have enacted restrictions on voting since the Shelby County's decision presumably would not have been able to do so without going through the pre-clearance process. It's unfortunately very hard to know the extent to which voter ID laws and other restrictive voting laws have repressed the vote, but we know for certain that there is at least an impact, particularly in close elections, when states have been able to systematically prevent certain populations from voting. And we know that this happened because of a combination of Supreme Court cases. So that brings us to 2020. So the Supreme Court over the course of this past spring and fall has heard a number of urgent cases. The first of which, and the most important that we should probably talk about, is RNC versus DNC that the Supreme Court heard last April. So this case is happening at the height of primary season, but also at the height of the COVID virus outbreak. And so at the time, Democrats in the state of Wisconsin were trying to make it easier for people to vote by mail. And they were concerned that with the coronavirus epidemic, that people would be concerned about going to the polls and that this would repress the vote. And so a district court judge in Wisconsin at the time extended the amount of time that voters had to turn in their mail-in ballots by a week. The DNC sued, arguing that the district court could not alter election rules. So another 5-4 decision, with the 5 Republican appointees siding with the RNC and the 4 Democratic appointees siding with the DNC. And so what this decision does is it prevents the state from extending the deadline for people to cast absentee ballots. So the court bases this on a precedent set in a 2006 case called Purcell versus Gonzalez. And so according to the courts, judges should have a limited role in altering election rules in close proximity to an election. And once again, they tell us that state legislatures control election laws. So we once again have the court saying that courts have a limited role and that state legislatures are the ones that are allowed to control election laws. So after this decision, the court hears a number of other emergency cases relying on this same logic. So I'd also like to talk about Ginsburg's dissent in this case. For those of you who aren't familiar with Ginsburg, the collars that she wears during her opinions tell you what she's thinking about her cases. So this particular collar that she has on is the one that she wears when she gives dissents. So I put her there in her dissenting collar, as she calls it. And so in the RNC versus DNC case, Ginsburg says that she's afraid that the court's order is going to lead to disenfranchisement because voters are going to have to choose between their own personal safety and exercising their right to vote. And then Ginsburg also points out that the court's not following its own standard. So she's basically saying the court's being hypocritical. So if courts shouldn't change election rules close to an election, then why is the Supreme Court changing an election rule even closer to the election than what the district court in Wisconsin did? And so Ginsburg raises her concerns, but unfortunately she is in the minority, sorry. And so whether or not you agree with Ginsburg's dissent, we do now have another major precedent from the Supreme Court saying courts stay out of this and state legislatures can essentially do what they want, even if it means limiting people's access to the ballot during a pandemic. All right, so 3 more emergency Supreme Court rulings that happened over the past few months that I'd like to talk about. The first is a case called Merrill versus People First of Alabama. So the Merrill decision does almost the exact same thing as the RNC versus DNC decision, except for in Alabama. And so a district court judge in Alabama was attempting to make it easier for people to vote in Alabama, and the Supreme Court struck that down, applying the Purcell logic that the court shouldn't be intervening close to an election, and that state legislatures were the ones who should get to control elections. Another case that happens in this time period is that the court hears Chalafalo versus Washington. And so this one's actually an interesting case because it's dealing with whether or not electors, so the people that we vote for to choose the president, have to adhere to the popular vote. And you get a rare unanimous decision from the Supreme Court saying that yes, they do in fact actually have to comply. Although I should point out, while that may be comforting to you, it also means that the opposite is true. So a state could empower its electors to simply vote however they choose. So once again, the argument here is that the states control this. All right, and then in last month, you have the decision of RNC et al. Versus Common Cause et al. And so in this case, the Supreme Court actually allowed Rhode Island to relax its voting regulations to make it easier to vote during the pandemic by a 6-3 vote. And what the court says here is that Rhode Island's attempt was constitutional while the other ones weren't, because the relaxing of its voting regulations actually came from the state legislature, not the courts. So 3 precedents, more or less really solidifying the fact that state legislatures control elections and what the court's role is quite limited. So from here, I actually want to talk about 2 cases that happened in the US Circuit Courts last week. And so the first one is Texas Democratic Party versus Abbott. And so this is a case involving the 26th Amendment, one that I don't recall having ever been controversial until 2020. So the 26th Amendment is a Vietnam-era amendment to the Constitution that addressed the problem that you could be drafted at the age of 18, but many states would not let you vote until you were 21. And so what the 26th Amendment does is it lowers the voting age to 18 across the United States. So the first time, once again, that I recall this being controversial is the year 2020. So Texas enacts a law that expands mail-in voting for people 65 and over. And so the point was that those 65 and over are more susceptible to the coronavirus and therefore should be able to vote by mail. Democrats in Texas, on the other hand, argue that this is partisan politics. 1, because we know that older voters tend to be Republicans, and 2, we know that younger voters are less likely to vote anyway, and that this is a way to further repress that vote for younger populations. They also argue that this is making it more dangerous and difficult for people between the ages of 18 and 65 to vote, with the argument that doing so violates the 26th Amendment. So the Fifth Circuit ruled on this last Thursday. And according to the Fifth Circuit, creating a benefit for one class of voters does not abridge the plaintiff's voting rights of everyone else. So according to the Fifth Circuit, this makes it easier for people over 65, and that's okay, because the law didn't actively do anything to make it harder for people 18 to 26. They just had to abide by the rules that were already in place. So there has been an urgent appeal to the Supreme Court to take this case also. However, if we apply the logic that they have in previous cases, I think it's unlikely that the Supreme Court's going to do very much about overturning what the Fifth Circuit did in this case. It's a law passed by the state legislature, and we're now becoming increasingly proximate to an election. All right, so the other case I want to talk about is dealing with the 24th Amendment, one that also until recently hasn't really been controversial. So the 24th Amendment did away with the poll tax. And so once again, the poll tax went away and we pretty much never talked about this again until the year 2020. So last Friday, the 11th Circuit heard a case called Kelvin Leon Jones versus the governor of Florida. And so in the year 2018, Florida voters passed a constitutional amendment that would allow ex-felons to vote. So Florida was one of the few states in the US where if you were convicted of a felony, you lost your right to vote forever. And so Florida voters actually amended their constitution to give that right to vote back to anyone except people who had been convicted of murder and rape. So after we have, once again, an expansion of rights to vote, the Florida legislature changed the definition of what it meant to finish your sentence in Florida to include anyone who still owed the state of Florida fines or fees. So Kelvin Leon Jones is an ex-felon who owes Florida money, and he argued that making them pay these fees to be able to get their right to vote back meant that they were essentially being asked to pay a poll tax. So the case before the 11th Amendment was whether or not the fees that Jones and other ex-felons were being required to pay constituted a poll tax. And at least according to the 11th Circuit, it did not. So the 11th Circuit says this isn't a tax on your right to vote, this is an extension of your sentence, and therefore you can be required to pay it. So I've read different figures on the percent of the population in Florida that's potentially impacted by this, but the numbers range from about 750,000 people to 1.4 million people in Florida that might lose their right to vote behind having to pay these fees. So this is also really important in a state like Florida where elections are decided by a few thousand votes. It's also really important because we know that mass incarceration has disproportionately impacted people of color. And so this case has the potential to disenfranchise over 1 million people and certainly has the potential to impact election outcomes in the state of Florida, given how close election margins really are in that state. So this case has actually been to the Supreme Court once already. And so at that time, the Supreme Court refused to implement the district court's injunction preventing the fee policy to go into place. So that policy actually is in place, and this case has now been appealed to the Supreme Court again. So the Supreme Court didn't address the constitutional question last time they heard this case. So I actually think this one has a greater probability of going to the Supreme Court and a greater probability of the Supreme Court giving us a constitutional interpretation. However, I think it's unclear whether or not they're going to be able to do this in a time that it might actually impact the election. So we don't know when they're willing to hear this case or if they're willing to make an urgent decision. And presumably it's already impacting whether or not ex-felons in Florida are even being able to register to vote for the 2020 election. So I think it's an important case to watch and will certainly have important implications going forward, but its impact on our current election cycle, I think, is unclear. So let's put all this together. So based on everything we've talked about so far, where are we? All right, so 1, state legislatures control elections, and they're allowed a whole lot of latitude because that's where the Constitution places the ability to control elections. And it's why we have so much variation from state to state. So some states are making it harder to vote while other states are making it easier. All right, next. Voting rights are not guaranteed to all citizens. Third, states can and do enact restrictions on voting that target specific populations. And for the most part, those have been upheld by the Supreme Court. We also know that courts have a very limited role, especially with election proximity. And we know that the Supreme Court has been, in recent years anyway, very divided on those issues along partisan lines. So this is where the right to vote currently stands. So we have a lot of states doing a lot of different things, and a divided Supreme Court largely staying out of these issues and allowing states to do what they want. So we'll go back to my original graphic of threats to voting in the year 2020. And so there are certainly things that we can do to start to address some, if not all, of these concerns. But I decided I would start with the last one there that's in bold. And so the first thing that we can all do if we want to do something about voting is to start to address the apathy and disillusionment problem. So the first thing that you can do, all of us can do, is register to vote. The deadline in New Jersey is October 13th. And if you do not want to go to the polls during a pandemic, you can register for a ballot by mail up until a week before the election in New Jersey. So those are two things we can do immediately right now, is to register and to actually vote, and to ensure that you are able to get a ballot delivered to your house if you don't want to go to the polls. So the other thing that a student in my class last week actually pointed out, and I wish I remember which student said this so I could give the student credit, but the student said, we don't elect the Supreme Court, but in a way we kind of do. And I said, yeah, you're kind of right. And so the student's point was that while we don't actually elect the judges on the Supreme Court, who we elect as president does directly shape what the Supreme Court looks like. And so in a lot of ways, the Supreme Court actually is on the ballot. I imagine most of us would like to see a less partisan, less ideological, less contentious Supreme Court. I don't think that that's likely in the near future. However, the direction that the Supreme Court does take ideologically in the future is definitely up for grabs. And so regardless of one's position on this, I think it is important to think about the fact that the next president will likely get to appoint probably 2 justices to the Supreme Court, which certainly could, as you've already seen on many of these 5-4 decisions, determine which the outcome on these cases could have been quite different. So something else to keep in mind is that the Supreme Court is also very much a part of what's happening at the next election. All right, so more things that you can do, particularly if you're a TCNJ student. So the first one is you can work at the polls during election. There's a link to do that if you are interested. There is very much a need for people to help out. You can also get involved with lots of national and local groups that you can support that care about voting rights and issues of civil rights and social justice. And so you have a list there of a few groups that you actually could become involved with and support. There's also a local community group, the Latin American Legal Defense Fund, who works with immigrant populations for citizenship and voting rights. And then the last one, I think, is also really important. And that is that we need to combat the broad-based disillusionment out there with voting. So we know that voter fraud is largely a myth, much like it was in Indiana in 2008. The biggest thing that people who want to manipulate elections are doing and are able to do is to manipulate voters. And so the biggest thing you can do to shift the outcome of an election, if you're a foreign government or if you're some other entity that's trying to shape what's happening in the United States, is to repress the vote. And so not only should you register and vote, but it's also very important that you're convincing the people around you that this is really important, perhaps now more than ever, that they are able to register and vote, and that we're able to dispel some of these rumors that voting about voter fraud or about the legitimacy of voting. And so I think the perception of these issues is also really important in terms of being able to dispel all of this. All right, so the other thing I would like to talk about while we're here is to actually go back to my previous slide. And what I have up there is the 28th Amendment. And so there are a number of constitutional scholars who argue that the real solution here to this problem and what we actually need is that we need to amend the Constitution such that it says that voting is an inherent right of citizenship, and that that right can't be abridged by being a convicted felon, being unable to pay fees, or any of these other things that have been used, not having a voter ID. And so what we could do is amend the Constitution so that we have a much more robust and rigorous protection for the right to vote. And so obviously that's a much longer term solution, but it's certainly one thing that we could potentially do if we really wanted to have stronger constitutional protections for the right to vote, and if we're hopeful that courts are able to more deeply protect our rights.